Hi, everyone. My name is Jen Chen, and I'm here to talk about immigration enforcement in the workplace today. We are dealing with a very different immigration enforcement environment. It's unprecedented and completely different from just a year ago or even 7 months ago. Um, Right now, it is a new era through the passage of the One Big Beautiful Bill Act. ICE, Immigration and Customs Enforcement, is now the most funded law enforcement agency in the United States. ICE is expected to receive over around 75 billion in funding in the next 4 years, and that does not include the 10 billion in funding for already allocated by Congress this year. Also concerning is that USCIS, United States Immigration and Citizenship Services, which historically has been a benefits providing agency, has now also received enforcement powers. So we do expect a high uptick of enforcement related actions for our employers. One of the most drastic differences we have seen for employee management is in terms of employee mobility. So if you have foreign national employees, please make sure they are aware to check in with you before any international travel. Right now, international travel is heightened and risky due to a number of factors. As everyone might have heard on the news, the president signed a proclamation late on Friday requiring a new $100,000 fee for H-1B petitions. There's still some confusion over how this policy will be implemented. Since the confusion on Friday, the government has clarified on Saturday that this should not apply to existing H-1B visa holders, and it should only apply to new H-1B petitions coming up for the fiscal year 2020, for the next fiscal year of 2026. However, there are still some issues of concern, mainly related to change of employer petitions and cap exempt petitions, and how, practically speaking, this $100,000 fee will be collected and implemented and when it will be triggered. Also, through the passage of the One Big Beautiful Bill Act, there has been new fees for visa issuance, specifically a visa integrity fee. So we do urge clients to let your foreign national employees know that travel will come with additional costs. And on top of that, with new proclamations related to enhanced vetting, which practically speaking will mean longer processing times for visa issuance. We have already seen this for a number of cases, specifically if your foreign national has any criminal record or has even any interaction with law enforcement in the past, was convicted but not charged, things like that. We really urge caution in terms of international travel right now. The government also announced Project Firewall, which will look closely at H-1Bs and H-1B restrictions. So overall, right now, employee mobility is an issue of concern. We would urge folks who are traveling internationally, you check in with your employers beforehand. If you're an employer, be sure to communicate this with your employees so that they know that they need to check in with you before traveling internationally. Make sure you have good remote work policies in place. For those in the bio data or biomedical industry, please make sure there's also new restrictions related to data sharing, especially for people who are working from sensitive locations or are from sensitive designated countries such as China, Iran, North Korea, and the such. What does this mean for HRs and how do you manage your workforce? At this time, we are recommending audits for internal audits for all our employers. Be sure you are checking your I-9s and staying up to date with your I-9s. Make sure you're conducting internal audits regularly for your I-9s. We have a very good training on YouTube from my colleague Cody Nunn on I-9 policies. You can search for that. It is available online for free. And we also, here at Swanson, we have an immigration team ready to support your internal I-9 audits. On top of the I-9 audits, make sure your your team has a response plan in place in case of government visits. You want to make sure your receptionist and other public-facing individuals know who to call before allowing a government official on site. Many of our employers have designated specific representatives, and so a good response might be, I am not the designated representative and I cannot let you into the facility, but let me contact them so they know you are here. And additional internal training is making sure your teams are aware of folks who are in various immigration statuses. The most recent update and breaking news we have heard from immigration attorneys is that the government, specifically the Fraud Detection and National Security Unit, FDNS, with USCIS is now conducting unannounced site visits to check up on folks who have hired international students. These are people working with optional practical training, OPT, STEM OPT, or curricular practical training, CPT. So if you have a foreign national workforce, make sure that you are aware what is your work authorization, on what basis are you working, and also, are you working in line with those restrictions? If it's a H-1B, are we being tied to the work site? Are we not moving them around when they shouldn't? If they are an OPT or CPT, are we giving them their required hours? Are we conducting their trainings and performance plans as required? Again, this is the time to be looking at your internal policies and your internal processes to make sure that you have good processes in place and to avoid any unnecessary scrutiny from the government.